Wanted to talk about some of the frequently asked questions about direct democracy here in California. So, for those who are not familiar, I put together these questions and answers for queries that I found are most often posed regarding the three forms of direct democracy here in California. So, let's go through them. What is an initiative? The initiative is the power of the state's voters to propose statutes and amendments to the Constitution. How does someone propose an initiative? An initiative measure may be proposed by presenting the Secretary of State a petition that sets forth the text of the proposed statute or amendment to the Constitution, and it's certified to have been signed by the required number of registered voters. What are the signature requirements for an initiative? Well, voters equal in number to 5% for a statutory initiative or 8% for a constitutional amendment initiative of the votes for all the candidates for governor at the last gubernatorial election. Does an initiative have to appear on the next general election ballot? Generally, yes, unless the governor calls a special statewide election for that particular measure. Can an initiative cover multiple topics? No. An initiative measure embracing more than one subject may not be submitted to the electors, nor have any effect. What is a referendum? The referendum is the power of the state's voters to approve or reject statutes or parts of statutes. Are all statutes enacted by the legislature and governor subject to a referendum? No. The following types of bills are not subject to referendum: urgency statutes, statutes calling elections, and statutes providing for tax levies or appropriations for the usual current expenses of the state of California. When must a referendum be proposed? A referendum measure may be proposed by presenting to the Secretary of State within 90 days after the enactment date of the statute a petition that's certified to have been signed by the required number of voters. What are the signature requirements for a referendum? Voters equal in number to 5% of the votes for all the candidates for governor at the last gubernatorial election. Does the referendum apply to the entire statute? A referendum can ask that the statute or part of the statute be submitted to the state's voters. Does a referendum have to appear on the next general election ballot? Generally, yes, unless the governor calls a special statewide election for the referendum measure. When does an initiative or a referendum take effect? An initiative, statute, or referendum approved by a majority of voters takes effect on the fifth day after the Secretary of State files the statement of the vote for the election. However, the initiative measure may provide that it becomes operative after its effective date. What happens if a referendum qualifies for the ballot? Then the statute is delayed from going into effect unless the voters cast their ballot and approve or disapprove of the referendum. What happens when the provisions of two or more initiatives conflict with each other? If provisions of two or more measures approved at the state at the same election conflict with one another, then the provisions of the measure receiving the highest number of affirmative votes prevails. Can the legislature amend or repeal a voter approved statute? The legislature may amend or repeal an initiative statute by another statute that becomes effective only when approved by the voters, unless the voter approved initiative statute permits amendment or repeal without voter approval. What is the role of the Attorney General in an initiative or a referendum? Well, before circulation of an initiative or referendum petition for signatures, a copy of it must be submitted to the Attorney General, who must then prepare a title and summary of that measure. Is an initiative or referendum allowed at the local level in the state? Yes. Initiative and referendum powers may be exercised by the voters of each city or county under procedures that the legislature provides. Are there any prohibitions on initiatives? Yes. They cannot name any individual to hold any office or name or identify any private corporation to perform any function or to have any power or duty. What is a recall? Recall is the power of the voters to remove an elective officer. How does someone propose a recall? Recall of a state officer is initiated by delivering to the Secretary of State a petition alleging the reason for the recall, and the recall proponents have 160 days to file the signed petitions. Can the recall or the reason for that recall be reviewed by a court? No. What are the signature requirements for a recall? A petition to recall a statewide officer must be signed by voters equal to 12% of the last vote for that particular office. Also, signatures to recall legislators and judges of the courts of appeal and the trial courts must be equal to 20% of the last vote for that office. When must a recall election be called? An election to determine whether to recall an officer and, if appropriate, to elect a successor is to be called by the governor and held not less than 60 days nor more than 80 days from the date of the certification of the sufficient number of signatures. What is the vote requirement for a successful recall? All that is required is a majority vote to remove an officer. What is the vote requirement for the successor candidate? If there is a candidate, the candidate who receives a plurality of the votes is the successor. Who handles the recall duties if the governor is subject to a recall? That is the lieutenant governor. So those are my most frequently asked questions and their answers dealing with direct democracy here in the state of California.